So, first panel of the day, privacy in public spaces. What is public in the digital age? I'm going to do a bit of an introduction, then we're going to hear from our panelists, then we're going to, of course, have time for questions from you all. So, public. One of the definitions of public is exposed to the general view, and certainly a foundational principle of privacy law in the United States has been that your privacy rights depend whether you have a reasonable expectation of privacy. That reasonableness has been judged from a common sense totality of circumstances approach, regardless of whether it's been in a physical or a virtual area or space or activity. At what time, all that seemed fairly clear. But what does it mean in a world of, as we heard from Dean Vinhold and from our keynote, what does that mean in a world of drones and doorbell cameras and dash cams and body cams and cameras on everybody's everything, our phones, GPS, Internet of Things, pervasive technology in seemingly every corner of our lives? Surely, as Warren and Brandeis were wont to say in 1890 when they first articulated the first notions of what we'll call modern privacy, is I need a right to be let alone. But even our forefathers knew that that right is not absolute, and Sarah mentioned that there's not absolute prohibitions that would say right to be let alone, privacy is an all-being thing. That rather, that if there's a publication in the public interest is one articulation of when you don't have that right to be let alone. Now, to date, the digital world has generally been treated along the lines of traditional privacy. Most courts have concluded that once someone's voluntarily posted on social media, that there's no longer a reasonable expectation of privacy anymore. You give up that privacy by posting something on an accessible social media page, for instance. But when the public is in the camera's lens in one form or another, and it's everywhere, what does it mean? If your social media or other internet digital presence is public, should it be open and fair game for any usage? Should we expect that to be subject to data harvesting as a default? And I think you heard Tom and Sarah talk a lot about that. How should we feel about this given with what we've heard about Cambridge Analytica? Does it matter if the data is used for research, commerce and monetization? Again, questions we heard in the previous session. Law enforcement, government. So think about Ravi and his references to the Facebook Analytica challenges, the coffee shop, the 10-year Facebook challenge. And let me frame it one last way. As a legal privacy scholar, Joel Reidenberg wrote in a 2014 article, Privacy in Public, as government and private companies rapidly expand the infrastructure of surveillance, from cameras on every street corner to facial recognition for photographs on social media, privacy doctrines built on seclusion are at odds with technological advances. The Supreme Court at that time had recently been grappling with issues of technological capabilities undermining the meaning of the Fourth Amendment. Again, those exact things that Sarah was helping frame for us. And so Reidenberg argued that the conceptual problem derives from an evolution of 3 stages of development in the public nature of personal information that accumulates in the ubiquitous transparency of citizens. This ubiquitous transparency destroys any reasonable expectation of privacy. Each panelist is going to give us their perspective on these topics based on their work and their discipline. Then we'll open it up for discussions. And so without further ado, I'm going to tell you 3 interesting things about our panelists, and they'll then grapple with the topic a little bit. So first we have David Jurgens, assistant professor in our School of Information, who aside from degrees in philosophy and political science, also has a degree in computer science. So pretty darn well-rounded. More interesting to me is that David leads the Bringing Together Language and Behavior for Large-Scale Analytic Breakthroughs Laboratory, otherwise known as Blab Lab Lab, which is the best name ever. So kudos if that was your invention. Len is a professor of practice in our School of Law. Don't mess with Len. He's a 3rd-degree black belt in Taekwondo and has taught hundreds, maybe thousands of folks in the art of self-defense. Finally, A.J. Vincenz is a Knight Wallace Fellow and a journalist for Mother Jones. I almost said magazine, but a little to say Mother Jones. And frankly, we all kind of lead boring lives compared to A.J. Aside from being a journalist, he has a side gig where he works as a skateboard analyst and expert for ESPN's X Games, including assisting in their television production of the event with research and expertise on skateboarding and the athletes involved. So we have a place to digress if we so choose. So with that, I'm going to turn it over to David, and I think all we need to do is click forward with the clicker and take it away.
Thanks, Saul. All right, so I want to talk to you today about your data, your public data, with the notion that your data is actually very powerful. So I'm not necessarily a traditional privacy person. Instead, I kind of view myself as the person that is going to use your data to do things, for better or worse. And I want to convince you, or at least mention some of the things that we do with your public data. So your public data is actually really useful for important things like combating algorithmic bias. So where we have systematically put together ideas of discrimination. And just to give you an example, one example, we were looking at algorithmic bias and fixing it. On the x-axis here, we have something on the Human Development Index of a country, and they're producing some English messages. And on the y-axis, just as how good are our modern systems. And we showed that using publicly available data, sure enough, modern systems are pretty bad. But using your public data, we can also develop a better system to kind of combat that algorithmic bias and make the world a more equitable place. Similarly, looking at facial recognition software, so there's algorithmic bias with respect to skin color. So modern tools like Microsoft's face recognition system or Face++ have a strong gender discrimination against African American or darker skinned women. But our method sort of lifts that back up. So we've reduced the algorithmic bias, which is important for anything that has to do with facial recognition or just general face detection. Your data is also very useful for combating social ills. So, for example, India has a terrible problem with caste discrimination. So, depending on which caste you're born into, you may not have access to certain jobs or certain educational opportunities. And so, as a part of our research, we actually showed, this is cut off a little bit, we're actually able to measure the generational shift in openness towards caste using inter-caste marriage as a proxy for that. Moreover, we can even say that we can get geographic trends. So most researchers studying caste discrimination look for inter-caste marriage rates in terms of where they're actually taking place. And you see that in the East and the West, they're more common. But actually using your public data, we actually were able to show that there's actually a strong geographic trend that differs quite a bit from the lived reality. And there's something that's going on there that hasn't been explored. So your public data is showing information that actually is quite important. We can even look at sort of widespread gender bias. So it's perhaps unsurprising to some that signaling your gender online actually can lead to discrimination when you control for everything else. So if you look at the amount of unsupportive messages people receive across different types of social media, just signaling that you're a female in both your name and your writing just leads to this kind of torrent of unsupportiveness. We actually can quantify that. Your data is also pretty powerful for like revealing human behavior, so kind of cooler aspects. So one of the things we're looking at is social relationships and looking at relationship dynamics. And you can see if you look at when do people contact each other, you can see that business relationships talk in the middle part of the day, and at the end of the day, sort of that romance peaks up. And we can start to think about how information diffuses in our social networks with respect to our relationships. Even just poking at that data thing is kind of a fun observation. Romantic couples differ. So if you look at that, maybe the 8 o'clock hour, no one's talking online to each other because it turns out we're married and we can home. We can just chat with each other there. So there's these kind of fun observations that we can get at that really play into the social dynamics. But of course, to get at that, we have to get access to certain parts of your public data. So we need your communication. We need your picture. Also your location, and your family and friend and coworkers, and we also need your dating profile. And so you may say, that's a bit more comfortable than I'm willing, but you also may say, hey, I don't share any of that. That's not my problem. But of course, even if you don't reveal much, one of the things that we do in my lab is we use social data to infer things about people who don't share it. So if we know nothing about you, well, we may know something about your friends. And if one of them says something, well, homophily, or the idea that you're similar to your peers, plays a pretty strong role in us being able to infer things. And when you play that out across the whole social network, well, we learn a few things about a few people across it, and we're able to infer quite a bit. So even if you're not participating, we're able to still infer quite a bit. So the idea is that what is public about you isn't necessarily what you post. It's sort of a function of both what you post and what all of your friends and their friends and the larger social network is. So there's this giant social context going on. And this actually now carries substantial weight. So for example, the US visa and citizenship applications now ask you for your social media handles. So whether what your friends say may influence something that could be inferred about you, and that may deny you access to this. Similarly, getting access to health insurance, you may get a discount based on your social media handle. But if your friends or you suggest that you may have a proclivity to, say, mental depression, that may lead you to be denied health insurance. And similarly, you can even in job applications or even college entrance exams may ask for your social media handle. And again, given what's public, you may not even know what could be used for or against you in these cases. So I want to sort of pose this question that your data is public and powerful, and for some of the reasons that I've shown earlier, but what is public about you isn't necessarily known, and what is available may not be just alone what you've said. And so it's this question of who gets to wield that power. So I think these are sort of the two big questions that we grapple with in my lab and our research, but I think these are very important questions to think about with respect to your public data. So that, I'll turn it over.
Afternoon, thanks for being here. Well, as the representative of the law school, let me begin with a lawyerly disclaimer. I'm not a privacy scholar. My work is mostly in the field of First Amendment, free expression. At times you may think I don't know what I'm talking about. You'll probably be right. So with expectations appropriately adjusted, let me begin. As a general proposition, existing legal doctrine within the United States views the concept of privacy in public as incoherent. In fact, as, that's okay. Keep going. Data is attacking us as we say here. So as a general proposition, existing legal doctrine within the United States views the concept of privacy in public as oxymoronic, as being an internally incoherent notion. We don't think it makes any more sense to talk about privacy in public spaces than it does to talk about tall holes or tiny infinities or the walking dead. It's a contradiction in terms. And I want to point to two bodies of case law here, one that Sarah already referred to and another that we haven't gotten to yet. I want to start with the body of case law that we call tort law. This is the body of case law that allows people to bring civil claims against each other. And almost every state recognizes a type of tort claim called public disclosure of embarrassing private facts. Sometimes the law is hard to understand, but here the name of the tort tells you what the plaintiff has to prove. They have to prove a public disclosure of an embarrassing private fact. Among the things that they have to prove in order to maintain such a claim is that the fact in question was private. Consider a case I worked on a number of years ago. Consuelo Sanchez Duran served as a judge in Colombia in the 1980s. In that role, she heroically indicted the notorious drug lord Pablo Escobar, and as you might expect, threats against her life followed. She fled to the United States and settled in southeastern Michigan. While she was here, Judge Sanchez Duran and her husband used their real names. She openly served as the Colombian consul in Detroit. She had business cards with her name on them that she handed out. She and her husband rented apartments in their own names, shopped in public stores, ate at public restaurants. If they were hiding, you might say they were hiding in plain sight. In early 1989, the Detroit News reported on these events after alerting the judge that they intended to do it, and she and her husband subsequently brought a lawsuit against the Detroit News under multiple theories, including public disclosure of confidential private facts. The Michigan courts summarily rejected the claim, in part because the events were, quote, a matter of public record and were open to the public eye. So, for purposes of tort law, if it's happened in public, if it's publicly available, it's not private. The law of the Fourth Amendment that Sarah referred to earlier prohibits unreasonable government searches and seizures and embodies a similar principle. I should add to my list of non-credentials that I'm not a Fourth Amendment scholar either. But I do know enough to know that since the Katz decision in 1967, the Supreme Court has recognized that the Fourth Amendment doesn't apply to information that a person knowingly exposes to the public because you have no reasonable expectation of privacy, a phrase that Saul used earlier regarding that information. So, 1988 case, California versus Greenwood, Supreme Court holds that the defendant had no reasonable expectation of privacy in the contents of garbage bags that had been put out for collection. As you might guess, the bags contained incriminating evidence, including of drug use. The court pointed out that it is common knowledge that such discarded material is, and I love this quotation, quote, readily accessible to animals, children, scavengers, snoops, and other members of the public. So, if you put it out for the public, the fact that a snoop finds it is your fault, not their fault. Let's pause here to note that so far, things seem pretty simple. Our legal system generally views the idea of private life in public as nonsensical. Having made the world simple, now let me make it vastly more complicated. I'm a law professor, that's what we do. The first complication of particular relevance here relates to what it means for information to be readily accessible and therefore public. That's easy enough if the information is visible to the naked eye, like watching Judge Sanchez Duran go in and out of her apartment building. But does the information meet this criterion if it can only be secured through technological enhancements like a telephoto lens, a remote listening tool, a drone, or a tracking device? In general, and I'm speaking in very general terms here, courts have applied what we might call a human senses standard. So, for example, in 2001, the Supreme Court held that the police could not, without a warrant, use a heat-seeking device to probe the interior of a home from outside of it. The owner of the home, the court said, had a reasonable expectation of privacy in the information because the police needed special technology to access it. But are all technological enhancements problematic? Consider this. The court has long held that an individual has no reasonable expectation of privacy in information that the police can observe by the naked eye from an airplane or a helicopter. For example, a crop of marijuana growing in a walled backyard. Now, it's true that the police could see the marijuana through their own naked eyes, but it's also true that the police were not capable of levitating 1,000 feet in the air without the help of technology in order to do it. They needed an airplane. And so we must ask, what is the difference between a heat-seeking device as a sense-enhancing instrumentality and an airplane as a sense-enhancing instrumentality? Let's complicate things still further. Let's assume that I'm a police officer or a reporter who gets a tip that you're going around robbing stores. Every day, I wait outside your house in my car. I trail you wherever you go. I record the addresses where you stop. And just for the fun of it, I run a dashboard camera on my car so that I can record everything I'm watching with the naked eye. I'm on public streets the entire time. Our conventional notions of privacy would not view this as problematic because I'm just monitoring what you're doing out in the public sphere. But what if other kinds of devices are used to secure the identical information? Just last year, in a widely discussed opinion, Carpenter versus United States, the Supreme Court held that the defendant had a reasonable expectation of privacy in records showing the history of his cell phone locations. Prosecutors had used these records to secure Carpenter's conviction for a series of armed robberies in the Detroit area by showing his proximity at the relevant times to the pertinent spaces. Now, does it make sense if our standard is what we reasonably expect? Don't we today expect our cell phones to record our whereabouts more than we would expect someone to follow us around in a car with a running dashboard camera? Don't these principles lead us to the actually exact opposite conclusions that we think they would lead us to? And here's a second major complication that Sarah also referred to earlier. European legal systems, with which we interact with increasing frequency, have taken a wholly different tack, concluding that conduct engaged in publicly may deserve protection as private. For example, in a 2004 case involving the model Naomi Campbell, a British court found that a tabloid had violated her privacy by publishing a photograph of her on a public street where they had followed her as she emerged from a meeting of Narcotics Anonymous. Completely in plain sight, completely in the public, nevertheless, an invasion of privacy, the British court held. Now, before you get all giddy about European privacy law, let me underscore that a move in that direction would require two seismic shifts in our legal doctrine, at least as I see it. First, we would need to see free expression and privacy as co-equal values. And one of the challenges here is that I would suggest to you that although that we know under the Fourth Amendment, when we talk about privacy, we are talking about something that has the status of a right, once we get outside of constitutionally based arguments for privacy, it becomes increasingly unclear whether we're talking about a right or an interest. And the reason that makes a difference is because in our legal structure, under legal theory, well recognized. One of the characteristics of rights is that they trump interests. When rights and interests come into conflict, rights win. In the European system, they think of this as a dignity-based right, and so when it comes into conflict with other dignity-based rights, it has a chance that it sometimes doesn't when it comes into conflict in the US system. Secondly, where this has led the Europeans is to do a kind of ad hoc balancing. Is this a violation of privacy? Well, since it conflicts with other dignity-based rights, we have to do balancing. Balancing may have some virtues, but among them are not clarity, consistency, or predictive value. If you want to know whether something is a violation of privacy under the European system, you have to wait until a court answers the question. Well, I suspect I've created sufficient mischief to stimulate some further discussion, so I will stop there as your resident privacy tourist, but thank you for having me.
So like you said, my name is AJ Vicens. I'm a reporter at Mother Jones Magazine in Washington, D.C., but I'm actually here at the university this year as part of the Knight Wallace Fellowship for Journalists, and I'm happy to be here. It's a great place, and thank you, Saul, for inviting me. And as we're getting, disclaimers out of the way, I'm not an expert in really anything, but I cover cybersecurity and technology and data, particularly as it related to the previous election for Mother Jones, and so hopefully I can make a very simple point and we can hear again from the more smart people in the room. Do people, really think about the data they create, even if it's unwitting data? Do they care how it's used? People talk about Facebook all the time, and for an obvious reason, it's the elephant in the room when it comes to social media. More than 2 billion people, they claim, are active users between its 4 platforms, which are now in the process of being integrated. We're talking about hundreds of millions of photos, hundreds of millions of messages, very personal data flying back and forth, images, intimate conversations, political organizing, that sort of thing. And that's a lot of information. As has been pointed out, and as is quite obvious probably to everybody in this room, data is valuable. There's a reason that Mark Zuckerberg is the 5th richest person in the world, even after everything that happened for Facebook in 2018. Estimated net worth $71 billion. That's even after that rough year, he's doing okay. Didn't really hurt. As we all know, Zuckerberg had to go to Congress and answer for Cambridge Analytica and the data of 87 million Facebook users that was rolled up into that. There was also a separate data breach involving 50 million users. And that's also separate from the 146 million people who are estimated to have been impacted or exposed to information as part of the Russian disinformation campaign during the election. And that's all based on highly personalized data. So, there's also, this was last week, Facebook using data to target kids and how they interact with their app and spend money. And they are very good at knowing exactly who they're dealing with and using that information to generate money. So that was a fresh example of that. So after all of this, is Facebook worth it? Many people, I don't know. I mean, I don't know how to answer that question, honestly. People still use it all the time. But it's not just Facebook. Amazon, our lovely friend, has their Echo devices. Lots of people, I don't know if people in this room have these things in their homes. Answer your questions, tell you about the weather today, help you with a recipe, or maybe it'll build you a morning routine. But it might also get you locked up. Or it might send your private conversations to a contact in your contacts list or some other random Amazon user. Or it might just laugh at you in a creepy way and scare your kids, but they're working to fix it, so it's all good. Then there's also the data that you generate and is generated about you that you have no problem or no power in controlling. but it still gets caught up in data breaches and intelligence operations between countries. So what are you supposed to do about that? Or you might stay at a hotel. This came up earlier. The Starwood Breach includes birth dates, emails, credit card, passport numbers to a small group of people. I mean, that's out there now. You have no power over that. You just stayed at a hotel. Then there's data that, we all have these phones. And a story last week in Vice Motherboard, or a couple weeks ago, about data about your location being sold not only to people like bounty hunters and others, but perhaps, this reporter was able to buy this data. Sarah mentioned earlier, what if you are in an abusive relationship and your partner wants to track you down? It's scary times for data. We can't leave the government out of this. There was the Opm Data Breach, 2014, 2015. Data about some of the most sensitive employees the government has got in the hands of what was accused by the government of being Chinese hackers, but that could be spread to any number of places by this point. That includes the information used for background check applications, some of the most sensitive data that exists. That's not great. And now we mix in the Internet of Things. Your car is going to be connected to the Internet. Your refrigerator, your toothbrush, your toilet. So much data, like why is my question. But the fact is that it's happening and this is going on. And so my very simple point, and we'll get on with this, is that the question about what data is private and public is important to hash out, and there's a lot of smart people working on these questions all the time. But in my view, in reporting on this stuff, the horse has already left the barn, really. There's gobs of data about you and your communities and your family and your friends that's already out there, and it is public to a degree, or it is accessible to people who you may not consent to have that data, whether you want it to or not. And I feel like people should behave that way or sort of operate under that assumption. So that was the only point I wanted to make on this. Thank you.
All right, now we want to hear from you. So questions, please come on down to the mics we have. If you need to, we can run around with the mic. There was the drama. I thought that was the question. So I'll kick things off if nobody else wants to. So, Len, we heard a lot about especially in the U.S., the sort of legal basis for lack of privacy in a public setting. Has anything from what you heard from AJ or from David changed your mind that maybe the digital is different than the traditional physical way we've looked at things? I'm asking you to start.
You're asking me to start. No, I think, I think that in U.S. law we have a few really, really fundamental problems that make the conversation hard. The first thing is that we're all sitting here talking about privacy, and I'd suggest we actually don't know what we're talking about. We don't even know the status of the thing that we're talking about. We don't know whether we're talking about as an interest or a value or a right, and that seems to me a fundamental problem in terms of having a productive conversation. We don't know what it means for something to exist in a public space. This is law that's largely determined by reasonable expectations. And privacy scholars sort of reinvented that notion into a wonderful word. I don't know how many of you are familiar with this. Creepiness. At what point do you find something creepy? So the first time you go looking for a product, and then lo and behold, an ad pops up on your Facebook page showing you the same thing, the first time that happens, it's creepy. The second time, it's less creepy. The third time, you're disappointed if it didn't pop up. Where's the promotion for this thing I was just looking at with the great price, so forth and so on. So part of the dilemma, not just locally, but internationally, is that there is a vagueness built into this because it's organic. Our idea about what we expect and about what we find creepy and what we find predictable and okay is changing individually, I think culturally, on sort of a daily basis. And this just in, the law cannot keep up with technology. All technology moves faster than all law. And so here we have a situation where we have fundamental disagreements about what we're even talking about, where we have baked into it a notion that is organic and that will change rapidly, and where our ability to adjust for it legally, and I agree with everything Sarah said about needing more clarity around this, but our ability practically to keep a pace with those expectations, I think is a real challenge.
Okay, David, if you want to add to that, feel free to add. Otherwise, I will keep asking unless someone else is going to pop up.
Oh, I would add that one thing you said made me think of the fact that the way people are growing up now is online increasingly by default. I mean, you look at Snapchat, Instagram, Twitter, children, very young children in some cases are sharing just insanely personal details about themselves by default. So maybe they're not even thinking about how these things used to be or how private we were in the past or how cut off we were from everybody else in the past. And so, you talk about the standard, how it's just normal now, and I think that's totally right. I mean, they're just growing up this way. It's going to be how it is.
David, did you have any thoughts on sort of the normalization of what all of us call making the private self public? Okay, question.
Well, my question is related to that last point, actually. Professor Jurgens, when you were talking about how much information can be inferred about you based on what is known about your peers, so for all your efforts to opt out, it might be for naught because you're in an environment that has opted in, and whether that just brought to mind like the idea of like, do we need like herd immunization from data gathering for there to be any real effect? And what does it mean to get there to make it useful for someone who wants to opt out? Like, how do you truly opt out?
Tough question. I would say that I'm not even sure if we can herd immunize at this point. So there's a great paper that actually came out this week looking that even if you're not on the platform at all, as long as we know something about your peers that might be, we can infer quite a bit about you. And some of my own work, we've looked at things that aren't available on one platform. As long as you could say you tweet your LinkedIn handle somewhere, we can basically propagate information about you from one social network to another and infer it pretty accurately there. We also looked at things that like you don't do anything and your peers say things to you. Like, could you still be adversarial in that regard and like maybe talk to other people differently or like form friendships with people who are very different from you? And it's really tough to do it in a way that the platforms allow. So I'm not, I think there must be some way to do it, but it's not clear that it's sustainable or practical at any level right now on any of the platforms.
If I can just chime in, I sometimes say to my First Amendment students, if you want to understand why lots of free speech limitations get struck down, you have to understand one simple principle of legislative decision making, and that is that for every action there is an unequal and opposite overreaction. And there is this tendency to think that once we've identified a big problem, which this is, that we have to have a correspondingly big solution, which may not exist, right? And one of the things I found really interesting about Sarah's presentation is the idea that, yes, it would be good to have sort of a grander overarching theory, something that replicates the unity that we see in the European thinking about this, although, as I say, I think it's freighted with its own problems. But it's also true that there are things that we can do at more discrete levels to help make a difference, like the collection of information that is not necessary, really, in order for people to receive social benefits and things along those lines. So I think I'm used to playing the role of the fatalist, so this is uncharacteristic for me. But I do think it's important not to go from, it's really hard to figure out a solution to the big problem. It's important that we don't go from that to, there are no solutions to any of the problems that we're describing, because I think that's a false move.
Let me poke at that a little bit. So particularly based on what we heard from Sarah and your last statements, is there some sort of discernible space that we might want to consider carving with what I'll just call government-related surveillance of the public internet versus maybe consumer or for research purposes? Should we try to strike differences between the two based on power relationships, based on the ability of you to make consumer choices?
That. So this has also been in mind, like, would we want to carve out separate spaces? So one of the things we work on like discriminatory language and recognize that there's a lot of bad things said online. Can we help develop computer programs to recognize that, maybe help moderators out, sort of improve our online discourse? So for a while, Twitter actually has some robust privacy requirements where whatever you tweet, you own it. So I actually, as a researcher, can't share the content that you have tweeted. And if you delete it, then it's gone forever. But that actually makes it quite tough for me as a researcher because sometimes those tweets get deleted or banned, and therefore, like, all of our ability to like develop programs makes it tough. The other thing that's complicating it is if, say, you do carve out these separate spaces. So I work here in academia, but I have a friend that works in a government lab, and so if those two conflicts, if it's okay for research, but it's not for government use for surveillance, and now we want to collaborate. How do we do that with two different right structures, especially if the platform itself has different things? So that's my wrinkle to the problem.
Yeah, although it's not unusual to have different right structures. If the government kicks in your front door and engages in an unreasonable search and seizure of your house, that's a problem of constitutional magnitude. If I do it, it's a trespass. And so we actually think of those as having legally different significance. If you write an article and the government wants to stop you from publishing it and get a prior restraint, we think about that differently than if somebody cancels their subscription to Mother Jones, right? The public-private distinction and different rights regimes as to those is something we're actually sort of used to doing. But this gets, I think, really intriguing because, for example, if you look at the First Amendment area, the First Amendment applies to the University of Michigan because it's a public entity. It doesn't apply to Yale, but Yale has First Amendment arguments on its campus all the time because it applies normatively, right? Yale has adopted a set of norms that say we have to follow something that looks like the First Amendment. I think one of the interesting questions is, what are the principles that exist vis-a-vis the government that reflect norms that we have that can be picked up and moved over and dropped down into private spaces? And this is where I think it gets so complicated because the norms across the board are built on things like reasonable expectation and these kind of organic principles where people can and do disagree and where they seem to change very quickly.
On this topic of different standards and different ways of thinking about government action, I'm wondering what you think about government lurking on social media. So there are policies of, say, DHS and the FBI and so on that basically allow undisclosed participation in social media where they kind of can't instigate, they can't be agent provocateur, they can't try to like provoke you into, like committing a crime or saying certain things, but they can lurk, they can kind of passively observe. And do we see that as a First Amendment problem or a normative problem, or is it completely okay for the government to say, just lurk on a public discussion page for Black Lives Matter or a group like that? So I just was curious for your thoughts.
How many people have lurkers on your Facebook page, right, where you never, they watch because you'll see them, 4 days later and they'll say, hey, I see you went to, but you never see them comment. They never like anything, right? They're just kind of passively there, right? So let's see if we can come up with a difference. When a friend of mine named Cynthia lurks on my Facebook page, it does make me a little uneasy when I realize 4 days later that she's been lurking there. But Cynthia's different than the United States government in the sense that she doesn't hold a monopoly on legalized violence. She can't kill me. She can't imprison me. She can't execute me. She can't, there are all sorts of things that she can't do. So I feel differently about her lurking than I do about the government's lurking. But I think that still raises the question of what my expectations should be, right? Once there are lurkers, shouldn't my expectation be that anybody can be lurking, right? And so even though it may creep me out and I may react to it differently, I'm not sure that I can come up with a principled distinction for why I say, well, it's private when the government does it, but not private when this individual does it.
The question was, could there be a chilling effect if you knew the government was lurking over your shoulder?
Sure. But I think all reporters, every reporter I've ever represented who was doing political reporting always assumed that the government was watching what they were doing and monitoring it. And I represented reporters who were pursuing a story in the city of Detroit where the FBI was literally following them around because they knew more about the perpetrators than the FBI did. So that phenomenon, I think, predates our current state of affairs. But you're exactly right. Of course it can. It's always been the case that the government watching you can have a chilling effect.
So AJ, I'm going to pick on you for a second. Do you think that literally the government, in some form or another, whose ever government, is lurking over your shoulder?
My shoulder in particular, I don't know, but I do know that there are well-documented examples of the government lurking over not only journalists' shoulders, but activist shoulders, Black Lives Matter groups, not only lurking on their Facebook pages, but, false personas online, just hoovering up cell phone traffic and conversation with, mobile those devices that mimic cell phone towers, perhaps without warrants in a more of a dragnet sort of way. So I think that's the assumption should be that that is happening quite regularly.
And certainly thinking about stingray towers and things like that, it speaks to the evolution of technology. And what was easily once very private, because perhaps private in the sense that only the government could do it, and only the assumption is they are doing it under the right circumstances, warrants or subpoena. Now a lot of us, if not all of us, have the ability to have similar technology. And so what even was somewhat private can be more public. Yes.
Yeah, so I would like to ask a question to Professor Len Niehoff. Please excuse me if I'm mispronouncing your name. So I would appreciate your helping me think through what would constitute a seismic change in the constitutional order. I mean, the closest thing to my mind, being a person who has no knowledge of law, is the constitutional amendments after the Civil War. But maybe I'm wrong, maybe there is some other thing. So what would constitute a seismic shift like the one that you were saying would be necessary? What are the factors that drive them? And I am asking this question because I am thinking that perhaps that may help us think better about what are the kind of things that the public can do in order to advocate for some change in the legal framework in the US.
Sure. So let me describe it structurally. So if you have a structure where rights are defined by reference to a common underlying foundation, like human dignity, then you might say different things emanate from this recognition of human dignity. One might be a right to freedom of expression. One might be a right to privacy. And what you have there are two rights that are recognized coming from the same source that are of co-equal status. And so under a circumstance like that, you look at a situation like the Naomi Campbell case I gave you, and you can imagine a court saying, well, yes, there's a right to talk about that, but she also has some right not to be followed around when all she's trying to do is go to her Narcotics Anonymous meeting, right? And so what you have there is a structure that allows you to view those rights as being of equal footing, requiring equal weight, and then you're trying to figure out how to reconcile them and balance them. as Sarah completely correctly said earlier, the issue in U.S. law is that it's a patchwork. It's true that there are some that there are some forms of privacy, like the Fourth Amendment-based privacy, that have a constitutional base. There are other kinds of privacy that we recognize in our legal system that are not constitutionally based. And so you would have to figure out if you were going to amend the Constitution to raise those to the level of constitutional rights. There are some rights that are construed as being present in the Constitution, but they are implied. And so you have to figure out whether you think those are rights of equal stature or whether you think those are rights at all, given the fact that they've been implied. So what you would need to do to make this seismic shift that I'm describing is in my mind, a literal restructuring of the constitutional order to make things expressly stated that are not currently expressly stated, and to make clear that they are on equal footing. And that would be seismic.
My bad interpretation of that would be, can we take what we've derived as the penumbra of privacy and actually codify it in some form or another?
Yeah, and there are things that aren't even in the penumbras. There are things that aren't even in the penumbras that show up in state civil statutes and civil law and common law, where we recognize them as interests, but we don't really describe them as rights. And I would point out, by the way, that there's one thing you might notice is that I was really struck by Sarah's language, how often she uses the notion of control. But very often in privacy conversations, how often we use property metaphors, how often we talk about ownership, who owns a fact. And it's interesting how our language commoditizes the idea, because the minute we've commoditized it, then we've made it available to be used in lots of different kinds of ways. So I think that underlying structure actually shapes the metaphors that we use and even the way we think about it.
So last thoughts from anybody on the panel before doing a wrap-up? All right, well, I want to thank our panelists. So thank you, David, for describing the good of the public, the state of the power behind it, the good research that can happen out of it, and research with outcomes, but also acknowledging the bad. And so I think you'll find throughout, certainly the University of Michigan, I'd like to think academia as a whole, that we aren't the problem. We are pointing out that there are problems, even as there are positive benefits of using the data. And Len, thank you for the clarity and the confusion along the way. And AJ, thank you for grounding us in, sort of the real everyday observational way that this is of a concern and that we should care and that we do have a say and a power. So thank you all.